Okay, uh, let's make a start. It's fantastic to see all of you here. My name is Ewan McGaughey. I work here at the law school, and this is the first in a series of lectures about Labour's new economic policy, starting today with its reforms for labour law, and through the rest of the term, each Thursday, 6 p.m, right here, and sort of basement room downstairs somewhere for a couple of weeks, we will be going through some of the biggest package of reforms that we've really had since the 1970s, which really, I think, even if we don't agree with how far they should go, or if they're going too far, it's one of the most significant changes in economic policy in the British state in a generation, without a doubt. And I think that applies just as well to the Employment Rights Bill, which just happened to drop this afternoon. Completely unplanned, by the way. I had no idea that it was going to come on October the 10th, but here we are. So the format of this lecture and discussion series is going to be that I give a summary of the issues for the first half, and then the second half, we've got a fantastic panel of discussants who will kick off the conversation and hopefully bring everyone in the audience as well, asking this essential question: what should we be doing? Is the bill that we have today, are the bills that we're going to see coming over the start of this Parliament going far enough to achieve the goals that Labour, the new Labour government, has set for itself for growth and prosperity and equality, but also to comply with international human rights standards and turn around some of the problems that we've had? And I think that it's just worth remembering how much of a difficult period we are coming out of. We've had the longest fall in wages since the Industrial Revolution, since the global financial crisis and the beginning of the government in 2010. Life expectancies in Britain have stagnated or fallen, particularly since 2012 and the Social Care Act. 40,000 people in Britain every year die from air pollution. We still have an economy dependent on fossil fuels. And although the UK's fossil fuel use and greenhouse gas emissions have been falling, companies based in London on the FTSE 100, if we just look at the likes of BP and Shell and Glencore, emit around 13 times globally the entire carbon budget, or the entire greenhouse gas emissions of the whole UK. And then we've got all sorts of problems in education, which we'll talk about at the end, and we've just had a series of riots fueled by probably partly a lack of regulation of big tech media. So that's the big picture over the course of the term, and it's great to start off with employment rights. This lecture starts with some broad brush pledges that we've had from the government, and we're going to go through sort of four main areas, although there's lots that we could be talking about. But the four that we're going to focus on are single worker status, pay and hours, and then equality and job security. The big sort of overarching pledge made by Keir Starmer in his leadership bid for the leader of the Labour Party was that Labour would, under his leadership, stand up for working people, tackle insecure and low pay, pull down obstacles that limit opportunities and talent, reminding us that we are the party of the Equal Pay Act. And in general terms, this came into the manifesto in the following way: Labour's going to stop the chaos, turn the page, create partnership between business and trade unions, and we're going to implement the plan to make work pay, introducing legislation within 100 days. And here we are on day 97, and here is the legislation. They're going to consult fully on business, with business workers and civil society to put some of the parts of the legislation into practice. And actually there's quite a lot that is going to be consulted on, quite a lot that is subject to reviews. But I think it's very important that we start by covering what's also missing from the legislation. Today's going to be focusing really on more individual rights. Next week will be more focused on collective rights. So the first big issue is reform for single worker status. And through each of the sections, we're just going to run through the issues in the following way. First of all, what are the particular pledges? Second, why they matter, what the law is now in the UK, how the UK has been performing through its international rankings, options that we can see from around the world for reform, and the possible benefits and costs of reform. So the particular pledges that Labour has made in the New Deal for Working People and the Make Work Pay Plan was that there would be a single worker status which groups together what are known as employees at the moment and workers all into one, which would be distinct from the genuinely self-employed. And all workers under this single status would be entitled to the same basic rights and protections, also a promise to clamp down on bogus self-employment. Now that was the New Deal for Working People document, and then after negotiations between trade unions and, to be fair, a lot of lobbying from business, there was a further document called the Make Work Pay Plan with some subtle shifts, or some not so subtle shifts. In this case, it was that instead of being in this bill that we have today, the promise of a single worker status would be shifted into consultation to come later. So this is the first step, and there's going to be a very big set of arguments about what should be going into the bill, into a future bill. Why does this matter? It matters because it all determines who gets rights at work. Worker status, employee status is the gateway, as we know, for access to rights to work. And basically, if you're an employee at the moment, you get more rights. You get the right to notice before dismissal. You get the right to not be unfairly dismissed, redundancy pay, paid parental leave, statutory sick pay, and the right to a written statement of your contract. There's also a tax dimension and a national insurance dimension. If you are an employee, your employer pays 13.8% of your salary in national insurance contributions, which of course goes to the state pension, unemployment insurance. And if you're an employee, 8% of your salary will be contributed in national insurance contributions for your state pension. And the employer organises all the tax, of course. If you're an employee, you are also considered a worker. So you get all of the worker rights, which is the next category. What really matters here is that there's a group of people who are workers, but who are not employees. And that goes bigger. And so this group of worker rights that we have give us, if we're a non-employee worker, they give us the right to a minimum wage. Very important, they give us a right to be automatically enrolled in a workplace pension if we're between the pensionable age of 16 and 65. You get 28 days paid holidays. You have the right for your union to apply for statutory recognition. You're covered by the Equality Act and safety rights. But you have to organise your own income tax and national insurance contributions, but they are slightly lower if you are a non-employee worker. And then the third group of people is what we can refer to as the genuinely self-employed. That means that in law, at least, you don't have an employer, and you're responsible for all your own rights. You're meant to protect yourself, or the state has to cover you. So that means that we are very unusual in the UK. We have a three-tier system of worker protection. Up the top you see the sort of tax division between employee and self-employed. But for the purpose of rights, we've got the worker, who's also an employee, we've got the non-employee worker, and then we've got the genuinely self-employed. And to give you an idea of the scale, there's 28 million, roughly, employees in the UK, 4 million, roughly, self-employed people, but we just don't know how many people exactly are in the non-employee worker category because the boundaries are so unclear in law and have been litigated so much. So we do know that there are around 100,000 Uber drivers in the UK who the Supreme Court have told us are definitely workers. Not really said anything about whether they might be employees as well, as they are in most other countries. We have law firm partners who we know are workers, but not employees. There's about 27,000 of them. And then we've got people in the gig economy working for Deliveroo, Just Eats, Uber Eats and so on, who would often be considered employees abroad, but here at home they're in limbo, or there are very doubtful, very problematic court cases putting them into the self-employed category. So that's the sort of starting point for the UK. We've got this three-tier system, very unusual compared to other countries, and that contrasts dramatically with the position in international law. So under the Universal Declaration, which is ratified by a treaty signed by the UK, called the International Covenant on Economic, Social and Cultural Rights, everyone is entitled to social security. Everyone has the right to equal pay for equal work. Everyone has the right to just and favourable remuneration, fair pay. Everyone has the right to leisure. There's a universal scope as a starting point in international law. But then we have a division still when we look at the International Labour Organization conventions, because just because everyone has a right doesn't mean that there has to be an employer to guarantee it. It's very well accepted that the state is going to be responsible for some people and not others. So when we look at the International Labour Organization conventions, distinctions are drawn in the same way that most countries do between the employed and the self-employed. But the big difference here is the statements of principle that we get from the International Labour Organization recommendations. Labour law, it says, seeks to rectify unequal bargaining power between usually corporate employers and individual workers. Member states, when they are creating a labour rights protection system, should make sure that there's effective protection and that rights are certain, because uncertainty about the employment relationship usually works in favour of employers and against the interests of workers. And it recommends that in legislation there's clear definition of the conditions for defining an employment relationship, for example, using the concepts of subordination, dependence, or what it says in the preamble, unequal bargaining power. So when we look at the particulars of the law in the UK, and we're not going to get too bogged down in all the details. Actually, can I just ask, hands up if you're a lawyer in the room? Hands up if you've got a legal background. Hands up if you're a non-lawyer. Okay, good. So hopefully, this won't be too technical. The starting point is that UK legislation leaves it to the courts in the basics of whether somebody counts as an employee or not. Section 230 says you're an employee if you have a contract of employment, and that means a contract of service, but doesn't say what that means, so it's left to the courts. A worker is defined as somebody who personally performs work, not for a client or a customer, but says no more about it. So again, we look at case law. And we did have a provision in 1999, section 23, that says that ministers can extend protection. For instance, they could extend employee status to the Uber drivers, they could extend it to the Deliveroo cyclists if they wanted to, but it's never actually been done. So you can explicitly include certain categories of worker by order without a new act of parliament, but it hasn't been done yet. And another provision that is worth noting is section 203 of the Employment Rights Act 96, which says that if you have an agreement in a contract, it's void. If you have an agreement or a contract, it's void if a term would limit the operation of the Employment Rights Act. So that provision tells you that you shouldn't be able to contract out of mandatory statutory rights. You shouldn't be able to have a contract term or something in a contract that could be used to evade employment rights. But the problem is, when we've because we've left it to the courts in the UK, there's been a contradictory line of decisions dating back at least to 1983 and probably before that, particularly from 1983. One line of cases says that somebody is an employee and judged independently of the terms of the contract. So we look at things like economic reality, we look at various indicators like their use of their own tools, the amount of control that we exercise, but independent from the terms of the contract. And a conflicting line of cases says an employee or a worker is defined by terms in the contract. And the lawyers will know of the concepts of mutuality of obligation, or substitution clauses. And the problem with this is if you have legal tests which look at terms of the contract is invariably written by the employer, and that means that employment rights can be evaded. Here is a list, or just a very, very small sample of some of the conflicting cases. The red cases generally go against workers and generally have tests which look at the terms of the contract in order to define who is an employee or not. The green cases are more focused on legal tests, more focused on ignoring the contract terms. And in very quick summary, ready-mix concrete in 1968 holds that truck drivers are self-employed, even though they're wearing company uniforms, even though they're locked into the job, and are really dependent on the employer because they are in debt to the employer through a hire purchase agreement for the truck. Then it's sort of, think of a metronome, sort of going tick-tock, tick-tock, or tick-tock. Then, you know, tock the other way. Young and Wood and West in 1980 holds that a sheet metal worker is an employee despite a contract stating that he's self-employed. The court says it's primarily a question of law. But then tick in O'Kelly, the Court of Appeal, first appointee of the Master of the Rolls under Margaret Thatcher, holds that waiters working in a hotel in Park Lane are not employees because the employer had not undertaken to keep them employed on an ongoing basis. This is what we call the mutuality of obligation test and an umbrella contract. So they had no protection from dismissal for organising union. A really dramatically bad case that is an obvious violation of international law standards. But then TOC in Nethermere, the next year in 1984, you have a different judge in the Court of Appeal, different judges in the Court of Appeal. They held that home workers are employees, ignoring the O'Kelly test, and could claim unfair dismissal after a dispute over holiday pay. Then the other way, oh, by the way, depicted here is Derry Irvin, who was at 11 King's Bench Walk, and a pupil that he had at the time called Tony Blair. Derry Irvin did the O'Kelly case. Tony Blair did the Nethermere case. Derry Irvin won in his case before the Court of Appeal. Tony Blair lost in Nethermere and then went off into Parliament. But he got elected in 1997 and he appointed, guess who was his Lord Chancellor? Derry Irvin. And at the time, the head of the judiciary sitting in the House of Lords was the Lord Chancellor. And he just gives the leading decision in Carmichael, holding the tour guides for the National Power Company were not employees, and they had no right to get even a written statement of their contract. The other way, the Supreme Court holds in AutoCleanse that car valets are employees despite being hired through a subcontractor, so they did have a right to a minimum wage and paid holidays. But then the other side, Windle, court interpreters are held to be not even workers, as the employer had not undertaken to keep them employed. So using a contractual test, again, and not even covered by discrimination laws. Uber, the other way, tells us that we've got to take a purposive approach to interpreting statutes, holds that Uber drivers are at least workers, can get the minimum wage and holiday pay, although this is 9 years after Uber launched in the United Kingdom. It took a long time for them to get a remedy from the Supreme Court. And if you might think that, well, Uber drivers are in the gig economy, similar to Deliveroo cyclists, but no, the Supreme Court holds just a couple of years ago in Deliveroo that cyclists for Deliveroo are not even workers, and they don't even have the right to get statutory recognition or use the statutory recognition procedure for their union. And just recently, we had a slightly perplexing decision about part-time referees, PG Mole, which holds that referees were employees, but approves a whole line of cases going back to O'Kelly and this mutuality of obligation test that brings contractual terms into the criteria for being an employee. So the basic point is that the UK law is contradictory. It is nonsensical. It is all over the place in determining the basic question of who gets employment rights and therefore who has the whole panoply of protection under the Employment Rights Act, Trade Union Relations Act, and a lot more. And the upshot of this is that the UK ranks pretty badly if we look at our position compared to the rest of the world. in upholding rights. So this this chart comes from a data set from the Centre for Business Research in Cambridge, and it shows OECD countries ranked according to their protectiveness over worker status. You get a 1 if your test for worker status is primarily determined by law. You get a 0 if your test for worker status is primarily determined by the contract. And the UK, it was already right at the end, and after the deliveries decision, has probably gone down a bit. So it's amongst the worst in the OECD for protecting employment status. And that's really what is at stake in the reforms to employment law after the Employment Rights Bill that we've had today. The options or models that we have for changing how all this works are many. Nearly all countries just have the employee self-employed distinction. Most rich countries, as we said, use this idea of subordination or bargaining power, use a purpose of a test to delineate between employees and self-employed. We already have an option, as we said, in legislation to extend protection under Section 23 that could cover Deliveroo, cyclists, and so forth. But we could also look to other jurisdictions. Just recently, the EU has passed a platform work directive which says that there is an employee and a presumption of employment based on a set of objective criteria that look to the functions of what an employer does. We also have a status of worker bill, which I think was introduced in the House of Lords initially, which would combine workers and employees into a single status and distinguish those from people operating a business genuinely on their own account. But it might be useful if we have a future definition to explicitly do what the International Labour Organization says and spell out that contract terms are irrelevant and refer to things like subordination and bargaining power, as the ILO suggests. Now, why does this matter? We've got a 22 billion, fiscally, we've got a 22 billion black hole, we are told very often. And this could really help with the black hole, because if you expand worker status, which we're not doing today, but we could do soon, then very simply you'd have more revenue from national insurance contributions if you get more people in. And I won't go through all the calculations, but if you add up the Uber drivers, the delivery workers, the Uber Eats riders, and interestingly law firm partners, then just with those ones, you get about 1.1 billion from the gig economy. You get another 1.2 billion from treating law firm partners as employees for the purpose of tax. And it would probably be more than that, but it would come to around 11.5 billion over this parliament, just on those back-of-the-envelope calculations alone, by reforming for single worker status in accordance with international law. What are the costs of reform? Well, we don't really have much evidence of what the costs would be. On the contrary, arguments about reform that are negative often point to the lack of flexibility that might result, but these are largely theoretical, largely free from evidence, largely without any grounding in data. More importantly, a big study based on the Centre for Centre for Business Research data set in Cambridge, and a paper by Simon, who has joined us very kindly, suggests that stronger labour rights across the board correlate with all kinds of good things that we surely want to see, including higher employment, higher share of labour income, lower unemployment, and slightly higher productivity. So reforms to worker status really are something that could prove positive. Okay, so that's worker status, and we don't have it in the bill today, but there's going to be a very significant set of arguments and an intense amount of lobbying. Excuse me. We do have, however, some things in the bill that relate to the next topic on wages and working time, particularly 0 hours contracts. So let's go through those. The pledges of Labour were in the manifesto that it would change the Low Pay Commission's remit when it sets the minimum wage to account for the cost of living and have one adult status so that everyone gets the same minimum wage. And Labour would also ban 0 hours contracts. That was originally said in the New Deal. Slight change of emphasis in the Make Work Pay plan. It was said that there will be a ban on exploitative 0 hours contracts, and the same in the manifesto. Excuse me. The reason why this matters from a human rights perspective is what we've seen already. Everyone has the right to just and favourable remuneration, and the minimum wage and having sufficient hours at work are crucial to getting just and favourable remuneration. But UK law at the moment doesn't go very far in achieving that objective. So the Low Pay Commission remit doesn't take into account the cost of living. There's also no separate minimum wage. We just have one national minimum wage across the board. No separate minimum wage for different regions, like in London, where the cost of living is obviously a lot higher, or different sectors where people's productivity is higher, and therefore the pay could be as well, or different jobs or experience. And all of these things we see in minimum wage laws in the US, in Sweden, in Australia, and so on. And thirdly, employers are able to give contracts to staff that vary hours unilaterally. So that's what a 0 hours contract is in its essence. The employer gives you a contract and says, we can determine what your hours are, including down to 0. They have a discretion. And this puts us in a pretty bad place when we look at international rankings or the wage system taken as a whole, coupled together with the absence of adequate collective bargaining. This chart shows from the OECD's data and published in the FT, the UK in comparison to other major economies. You can see in the dark blue line, average wages in the UK are lower than where they were, or were lower when this chart was done in 2017, than they were in 2007. And other countries, very simply, are sharing more of the gains of growth with the working population. More bad news when we take a bigger step back. This chart shows average weekly wages when adjusted for inflation. And what we can see over time is that wages were rising, but then with the global financial crisis in 2008 and austerity beginning in 2010, UK wages have stagnated. And that was what I mentioned at the very beginning, the longest period of falling wages since the Industrial Revolution. You can see in an even bigger picture how consistently good we were from maybe sort of the end of the war up until 2010, making sure that wages did actually keep on going up with the rate of growth. The post-war trend was up, but not in the last 14 years. And what this leads to is a picture of the wage distribution in the UK, which is abnormal. A normal wage distribution curve would see some people earning low pay, and then like a bell curve, more people with middle incomes, and then fewer people with very high incomes. That's what we would call a normal distribution. And you see something like that in this chart, which depicts incomes in Germany in 1995. There's under €3 on the left-hand side, and then 30 euros an hour or more on the right-hand side. So you've got this normal bell curve distribution. But what's been happening in the UK since the 1980s is a bit like imagine that the vertex of the curve is a train and it's running into a wall. So like a big train wreck, we have, when we introduced the national minimum wage, what could have been a bell curve sort of bunching up at the lower end in the UK. That was in 1997. And in 2014, with the minimum wage, you have more and more people sort of smashing into the minimum wage wall. So we've become a low-income society. We've lost the sort of middle group of people who would be earning closer to the average and the median wage. And then on top of that, we've got an explosion of 0 hours contracts. So you can see there's one particular point at which the number of 0 hours contracts jump up dramatically, and that's between 2012 2013. One of the key reasons for this is that job centres start saying to people that they should get 0 hours, sorry, they should take work even if it's a 0 hours contract, reducing their discretion to say no to bad terms and conditions. So, these are very, very severe problems, and so it's important to look at what the options and models are for reform around the world. The best place to start is, in fact, a directive that has just been passed by the EU after Brexit. So the Adequate Minimum Wage Directive is predicated on the idea that if you want to get better minimum wages, then the best way to do that is to get fair wages. And you do that through spreading collective bargaining. So the Adequate Minimum Wage Directive says that member states have to have a plan under Article 4 to get over 80% collective bargaining coverage, or 80% collective agreement coverage. And we'll be focusing more on that next week when we talk about fair pay agreements in the UK. In this bill, we've got one fair pay agreement that's going to be set up in adult social care, but the rest of the sectors of the economy are being left. So by comparison, the UK has just under 30% collective agreement coverage, very, very far away from the goal that the EU is setting for all its member states of 80%. And in recital 16, it sort of gives you the rationale. Sectoral and cross-industry level collective bargaining is an essential factor for achieving adequate minimum wage protection and therefore needs to be promoted and strengthened. A second model is the United States. Believe it or not, there's a couple of things that are good in US labor law, and one of them is this provision in the Fair Labor Standards Act, which allows states and cities to set higher minimum wages than the federal level. A third option is to enable the Secretary of State to set minimum wage scales that are differential or can go up further than the baseline according to sectors, jobs and experience. We see this in Australia under the award system in the Australian Fair Work Act 2009. And a final option is to guarantee, on the topic of 0 hours contracts, guarantee the right to regular working hours in a contract with a maximum variation of 25%. This is the model that you find in German law. And this bill contains a different way of doing it. So remember, the pledge was to ban exploitative 0 hours contracts. What this bill, on my very, very quick reading today, and the 12 pages which it takes to explain the reforms to 0 hours contracts, it said that employers must offer a guaranteed set of guaranteed hours in a contract, but the way that they are going to do this and how the offer is going to be made is going to be set by regulations, and we don't know the content of those regulations yet. But this is the beginning of reform. Third topic is equality and parental leave. And there are two big issues. In fact, we could talk a great deal about the equality issues, but I just want to focus on one of the core ones of the gender pay gap and how it relates to pay. So the pledges of Labour in the manifesto were to review the parental leave system so that it best supports working families within the first year of government. So that's by July next year. Quite soon, this should start happening. Labour also pledges to enact the Socio-Economic Duty and Equality Act 2010, already passed under the last Labour government, strengthening rights to equal pay, protections from maternity and menopause discrimination and sexual harassment, and Labour will take action to reduce the gender pay gap, although exact ways in which this is done not quite yet articulated. The international law context is very simply, as a matter of principle, that everyone has the right to equal pay for equal work. And we are some way off that in Britain. We still have a gender pay gap of 14.3%. Depends on how you measure it and who you look at. But 14.3% is still pretty big, especially if you consider the first Equal Pay Act was passed more than 50 years ago in 1970. So 50 years, half a century of waiting, and we still haven't got equal pay for equal work. And so why not? What is our law missing? The first thing is we've had, since the Equal Pay Act, the right to claim that you should have equal pay compared to somebody else in your workplace if you've got a real comparator. Strangely, how do I put this, paradoxically or surprisingly, these rules on equal pay on the specific issue of sex, or comparison based on sex, are less generous in some ways compared to other equal pay rules on other on the basis of other protected characteristics such as race, disability, age, religion or belief, and so on. There's three main differences. First of all, you've got a 6-month time limit to claim at court, and this is non-extendable. Whereas for other kinds of equal pay claim, it's 3 months, but you can extend it, and that is very significant. Second, you've got to show that there's a real comparator who you're being treated less favourably than. And in other kinds of equal pay claims, you could appeal to a hypothetical comparator, somebody else who has a different race or a different ability to me, isn't disabled, can be a hypothetical comparator. You don't have to find somebody in real life, and that makes the claim harder. It is more generous in one sense, which is that you can go to a high court as well as an employment tribunal. But overall, you have separate and unequal rules, ironically, for equal pay. Second big issue is that parental leave and paid parental leave for childcare, maternity, paternity, adoption, and so forth, is very unequal. There is 2 weeks paid parental leave for fathers, 39 weeks for mothers, with some provision for shared leave. Maternity leave is paid at 90% of salary for 6 weeks only, 2 weeks for paternity leave, and then there's the statutory minimum wait for the remaining 33 weeks. And shared leave is talked about a lot, but actually only 5% of fathers and 1% of mothers take up sharing of parental leave. And so what this means in effect is that the vast majority of childcare falls on women. And that is one of the major drivers of the gender pay gap, because more time out of the workforce means that the gender pay gap will grow over time. This was agreed with by a study in Australia that found that major drivers of the gender pay gap there in Australia, pretty similar system to ours, were these three. Number one was unequal parenting. They attributed 39% of the gender pay gap to that. Second was outright discrimination, so the rules in the Equality Act or their equivalent just not being tough enough. And thirdly, occupational segregation. And we can see this in the data. So this chart, which is quite old now, but it's still useful, from, I think this is the IFS, says that the gender pay gap grows dramatically in the years after childbirth. And so when we look at where we fit overall in the UK compared to other countries, we are down in the bottom half of the OECD countries, gender pay gap over 14%. Countries that are doing well, by the way, have more sector-wide collective bargaining, and they have generally more equal parental leave rules. I can skip over that. Okay, so the models that we've got for reform are many again. First of all, we could do the simple thing of raising and equalizing paid parental leave up to 26 weeks as a standard, without allowing sharing, so it's a use it or lose it right, like holidays. This is what good companies in the UK are already doing. An organisation called Equileap identifies 11 leading companies which provide 26 weeks paid parental leave to all parents regardless of gender. And there's one, Aberdeen, that gives 40 weeks. Outside their sample is also UNICEF, which of course deals with the rights of the child, and they do 1 year as a standard regardless of gender. No country has fully equal rights by law, but Finland has a good model of 160 days leave for each parent. A maximum of 63 are transferable, and people get 70% of salary up to a cap of 41,000 euros, and then tapering off after that. Okay, and on to our last topic now. And I should say, in the bill we don't have, just to repeat, we don't have anything on parental leave yet. We do have some important provisions on maternity discrimination, so strengthening the rules surrounding discrimination and unfair dismissal for taking maternity leave. but the big review is going to come before next July. And then finally, we've got job security. So the two big things are dismissal protection from day one and banning the practice of fire and rehire. These were Labour's pledges. Labour will scrap qualifying time for basic rights such as unfair dismissal, sick pay and parental leave. This is promised in the New Deal document. But then the clarification after some consultation in the Make Work Pay document was to introduce this concept of, well, we can still have probationary periods. This will not prevent fair dismissal, which includes dismissal for reasons of capability, conduct or redundancy. Okay, that is what's already in the statute, or probationary periods with fair and transparent rules and processes. However, the changes will help to ensure that newly hired workers are not fired without reason or cause and will help drive up standards in the workplace. So that's what was said on day one rights, particularly for unfair dismissal. And then on fire and rehire, the government was saying that it would be mostly banned. Ending fire and rehire means workers can be safe in the knowledge that their terms and conditions negotiated in good faith can't be ripped up under the threat of dismissal. And the manifesto says that it will include provisions to end fire and rehire, introducing basic rights from day one to parental leave, sick pay, as we discussed, and protection from unfair dismissal. This matters from an international perspective because everyone has the right to social security, including job security. But the law on job security now in the UK is pretty minimal compared to other countries. So if we look at qualification periods, what would be undone by rights on day one? First of all, you've got to be sick for 4 days to get statutory sick pay. You've got to have worked for 1 month before you get 1 week's notice before dismissal. You have to have worked for 26 weeks before you get paid maternity leave, and so on. You need to have worked for 2 years before you get protection from unfair dismissal and redundancy pay if your job is no longer economically necessary. And there have been conflicting court cases which say different things about the extent to which employers can change your contract and worsen your terms rather than sacking you. In a case called Asda and Bateman, the High Court said that even the pay could be unilaterally changed if there was a broadly drafted variation clause that you sign at the beginning. Contrasted with the Court of Appeal decision in Wandsworth and De Silva that says that changes or variations were subject to an implied term of mutual trust and confidence. So courts have enabled also for employees to be dismissed if employees refuse to accept a unilateral change as part of a restructuring package. So if the employer needs to restructure the way its business works, then they can say that there is, and the employee refuses to accept worse terms, then the employers are allowed to say that this counts as some other substantial reason for a dismissal and drive through the restructure and change the terms. Also, there are very weak provisions at the moment for consultation over large numbers of redundancies, over 20 people. And some of this is, in fact, all of this is being tackled in the bill. The international rank of the UK at the moment, you can see a pattern emerging here compared to the other ones, is unfortunately pretty bad. So this chart, again, from the Centre for Business Research, shows countries with a 1 that have no or very, very small qualification periods or negligible qualification periods before you can claim unfair dismissal. And right down the end, you've got United States and Costa Rica who have no right to unfair dismissal at all, and closely snapping at their heels is the United Kingdom with our 2-year qualification period currently. And it's important to see, let's just talk about what's in the Employment Rights Bill today. It is said by the government that there will be day 1 rights for unfair dismissal, but under Schedule 2, there's a power for the government to pass regulations to bring in probation periods which modify what the unfair dismissal protection will be. And we don't know what that modification will actually mean. Business has been lobbying very, very hard for a probation period to mean exactly the same thing as a qualification period. In other words, you don't get the right. The unions have been saying, well, you can have probation periods, but that doesn't need to affect getting day one rights at all. And the way that this sort of political disagreement is being resolved is to decide it later. If we did have what the government has announced it intends to do, either 6 or 9 months as a probation period, if that meant the same thing as a qualification period, then the UK would improve slightly from the 3rd worst in the OECD to the 7th worst in the OECD, because either 6 or 9 months is very much longer than the norm, which is that you get day one rights, or most countries do up to a very maximum of 3 months. Okay, so models for reform. First of all, as we said, a 6-month probation period or any probation period doesn't need to affect day one rights. As with the expiry of a fixed-term contract under the current law, reasons to not pass probation can still be required by law to be fair. We can also look to a bill that's being put into Parliament called the Employment and Trade Union Rights Dismissal and Re-engagement Bill, which would ban renegotiation of contract terms under the threat of dismissal and improve remedies for breach of consultation duties with unions. What the bill that we've got today does is it says that or variation of contracts unilaterally by the employer are not allowed, but there's an exception if the employer is undergoing, and forgive me for getting the terminology not quite accurate, if the company is in financial distress or if they are facing severe financial difficulty, so long as they show that they have also consulted with unions. So there is a ban on rehire on the face of it, but there's this exception if the employer can argue it was really, really necessary. And the details of how that plays out are unknown. A way that we could go even further than the bill that was introduced just up here is look to other countries, I beg your pardon, I should have gone to this slide, is to look to other countries which increase the voice of workers in the redundancy or the dismissal process. So Germany's Work Constitution Act says that you can have elected bodies of workers, which 80% of which are trade union officials, that can halt unfair dismissals if they don't think that the dismissal is fair, and they can also delay redundancies pending binding arbitration or a decision by a court, which can impose a very substantial social compensation plan. And this mechanism of internal voice is very useful for the German system of productivity and the way that they respond to crises. For instance, during COVID and also in the financial crisis, work councils negotiated reductions in working time, temporary reductions in pay, just as long as it was covering everyone, rather than having people lose their jobs. And that meant that you didn't have the big spikes in Germany during COVID and the financial crisis of unemployment that you did in the UK, even worse in America. Okay, so that concludes the first half of the lecture. Almost, one more slide. Benefits and costs of reform. We have another great paper by Acharya and others showing that improved job security rights, employment protection legislation, including extensive consultation, workers on the boards of directors, which we'll talk about next week, leads to increased innovation. The idea here is that if you have more job security, then you're more likely to think creatively and innovate. And they measure that by the number of patent filings going up. In the paper that we saw earlier, you also see that higher employment protection legislation, including job security rights, generally correlate with slightly higher productivity, higher labour share of income, lower unemployment, and higher employment. Okay, so these are the discussion questions for the next half. And in a second, I'll invite our discussants up. So first of all, what should an employment bill the Employment Rights Bill or a future one say on the definition of worker and employee status? You know, what reforms should we be expecting through the consultation period or the review that's going to happen now? Secondly, what needs to be done to ensure adequate minimum wages? I mean, what do you think the best models are? We've got lots and lots of options. None of them are necessarily the right one. But what could we do to get wages up? And thirdly, how should the Equality Act, paid parental leave rules be reformed to undo the gender pay gap? And finally, does the employment bill go far enough in securing jobs? And if not, what is needed? So with that, I'd like to invite our discussants up onto the stage. I think that there are stairs somewhere. And we can kick off the discussion. And I think the stairs are around that way, this way. So I think we've got a microphone as well. The way I wanted to do this was just ask each of you to make remarks for 5 or so minutes, and perhaps we could start in this direction. I also need to introduce everybody. So starting off with Gwyneth Pitt, who's a professor at Kingston, author of a leading textbook on employment law, and am I also allowed to say had a very famous student once upon a time who was Keir Starmer when he was studying law in Leeds. Then we've got Lord John Hendy, King's Counsel, who is also the chair of the Institute for Employment Rights. We've got Lydia Hayes, who's a professor at Liverpool and is an expert in cost of living, and done lots of research recently on food banks and the problems that workers are facing in the cost of living crisis. And Simon Deakin, Professor of Law at Cambridge, who is also running the Centre for Business Research, which has produced a lot of the data that we have seen already. So, Gwyneth, could we perhaps start with you? Would that be okay? Please just take it away and give us your reflections on where we should be going. Does that one work? Or this one?
Okay. Hello. I'm sure people would like to. Is that working? Can you hear me all right? Yeah? I'm sure people would like to contribute themselves, so I'm going to keep my remarks very short. And I want to talk just briefly about worker status, the employment status issue, fire and rehire, and then a few things which I hoped would be in the bill, but which aren't as far as I can see. I have spent the afternoon looking at it, but I may well have missed something. It was rather longer than I expected. So, in relation to employment status, Ewan has mentioned already that there is a power already existing to extend employee status to workers if that's wanted. I think myself that we are at a situation where we have got to have a new statutory definition of employee and or worker. Whether it's a combined one, I think it should be a combined one, but I think it's got to be a statutory definition because I think we need to revisit the personal service requirement, and that is absolutely essential in the light of the Deliveroo case. So that is what I would see as being necessary there. In relation to fire and rehire, it will be remembered that the P&O case, where P&O kind of got rid of, was it 600, more than that?
796.
Thank you. 796, you can probably name them, John. Marius, I think by text message, pretty much. Of course, in that case, it was not a fire and rehire, it was a fire and not hire, because the company was planning to fire them without following any of the statutory procedures that were required, and to use agency workers who were going to be much cheaper instead. Now, the bill does address both fire and rehire and fire and finding a different infant workforce in so far as it can. I think that it would be an automatic unfair dismissal is what the bill is proposing if that should happen. And that will help. I'm also much encouraged in relation to fire and rehire by the recent Supreme Court decision in the Tesco and Astor case, where the Supreme Court actually granted a final injunction to stop Tesco from going back on its promise to give permanent protection to workers who had accepted a variation in their contracts. And I think that shows a possible way forward in relation to at least some clauses which have been incorporated into contracts of employment, a way of enforcing contracts of employment. I'm perhaps less convinced that than Ewan is that the answer is by statute rather than by contract in some of these matters. But I do think in relation to fire and rehire, what will have to be looked out for is the tendency to use express variation clauses in contracts. Ewan mentioned Bateman and Asda. If an employer retains the right under the contract to vary the contract, then we're no further forward on this. And of course, it's going to be situations where there aren't trade unions and there isn't strong collective bargaining where that is likely to happen. So finally, a couple of things which I hoped would be in the bill but aren't. The Law Commission recommended in 2020 that the limitation period for all employment tribunal claims should be 6 months. That seems sensible, it's not there. They recommended that the limit to contract claims in tribunals should be raised to £100,000 because it hasn't been changed since 1994. That's not in there, unfortunately, I don't think. Equality I won't touch on because I'm sure others will, but I would have liked to see the socio-economic duty, which was a very original and important feature of the 2010 Equality Act, never brought into force. It would have been nice to see considerations bringing that into force, and unfortunately it's not there. Thank you.
Thanks, Gwyneth, and thanks, Ewan, for that very broad review of labour law. Some of those cases I don't think I've looked at since I was a law student. But, I wanted to make the more, like everybody else on the platform, we spent the afternoon going through this bill, all 149 pages of it. So I wanted to give a couple of reflections on that, really. I mean, it would be churlish not to congratulate the government on doing something on individual rights, and what they've done is going to be significant without a doubt. But they have failed, in my view, to address the real problem of working people in this country. The statistics in relation to whom Ewan gave earlier on, stagnant wages for 14 years and so on, degrees of inequality that we haven't seen since the 1950s, or perhaps earlier than that. The real problem is not lack of rights, it's lack of power. And that, to me, means that the collective measures in the bill should have been a lot stronger than they are. I mean, there's nothing wrong with individual rights, except that you have to remember the problems that arise. One of them, Gwyneth has already mentioned, the 3-month time limit. The new rights that are proposed in the first part of this bill reintroduce the 3-month time limit. There's no suggestion of extension of the time limit. They also reproduce further arbitrary caps on compensation, whereas the New Deal for working people committed the Labour Party to remove all arbitrary caps on compensation, but to make sure that compensation was the proper measure of loss of the individual workers. And we know too from statistics that were collected 12 years ago now that even where awards are made by employment tribunals, 1/3 third of the workers don't get the whole amount of their awards. The employers go bust or refuse to pay. And we also know, all the lawyers amongst us, I didn't see how many hands were raised, but the lawyers amongst us know how difficult it is to win a case in an employment tribunal. The statistics speak for themselves, categorised by each area of the law. Some of them are tiny, and the results, for example, of awards of reinstatement or re-engagement are infinitesimally small. So that, and of course we now know the delays in the employment tribunal system, 4-day cases being listed 2 years ahead. Somebody in my chambers was telling me they got a case, 4-day case listed in 2026. I mean, what sort of justice is that? So many workers, the idea of having employment rights are of course beneficial, and they have a normative effect in the sense that good employers will abide by the law. But those that don't make it very difficult for workers to benefit from employment rights. Well, turning to collective rights, I won't deal with collective bargaining. I think Lydia is going to say something about that. But just the law on industrial action. There are measures in the bill which deal with the law on industrial action. Workers are now allowed to have electronic balloting instead of fully postal ballots. But the New Deal for Working People specified absolutely clearly, and it was reproduced in Making Work Pay, that balloting should be either workplace balloting or electronic balloting. Now, workplace balloting is now has been eliminated from the current proposals. It also, the New Deal recommended that the requirement to give notice of a ballot, let alone notice of industrial action, should be removed. It's still there. True, there are certain simplifications to the notice that needs to be given, and the period of notice has been reduced from 14 days to 7 days. But one of the, I won't go through any more detail, but one of the really key proposals in the New Deal for Working People was that the UK law on industrial action should conform to the obligations of the United Kingdom undertaken voluntarily and ratified by the UK. And they are ILO Convention 87 and the European Social Charter Article 6.4, which protects the right to strike. That has not a trace in this bill, not a hint, not a mention. And that means that the real problem of loss of trade union power and hence of worker power, which is really essential to address the living conditions of working class people in this country, will not be touched by this bill. I'll remind you that the particular provisions that have been criticised, the particular provisions of industrial action law have been criticised by the supervisory bodies of the European Social Charter and the ILO on every single occasion in which the industrial action law of the United Kingdom has been considered by the supervisory bodies, not just in the last 10 years, but since 1989. Every single occasion, the governments of this country have been reminded that our laws are not in conformity with the obligations undertaken by the United Kingdom. I could go on by using up other people's time.
You can go on afterwards, but
what I wanted to say really builds on what John has said. I think it's very important that we take a broad view of this and actually think, when we look at this new bill, what is its purpose? What is it for? What issues is it addressing? And Ewan has very usefully provided that broad context. We are in a mess as far as the labour market is concerned, the economy, poor productivity. And might I say, one other doom slide that Ewan could have included was to do with the state of public health, not just the longevity issues, but rising mental health, particularly among young people. These are not good omens for the economy. These issues need to be fixed. And people are crying out for these issues to be fixed. So what is the point of improving individual labour rights? Well, the economy needs, particularly low-paid workers, need more security. And we need to improve levels of legal literacy. So people generally have very little awareness of what their employment rights are. And is it any surprise, given Ewan's long list of your red cases and your green cases and your red cases? You know, it's interesting and complex to us as lawyers, but to working people, what on earth are their expectations? What are legal literacy levels? Particularly when it's so difficult to actually enforce those rights. So we have to see that the current situation that we are in the economy and the labour market is to do with a very complex interweaving of different measures that have been taken over a lengthy period of time. John will point to the last 40 years in particular around anti-trade union law, but Ewan's illustrated the importance of consideration of changes to welfare law since 2010. We need to think about changes in terms of legal aid and support for people going to the tribunals, the lack of support for funding for the employment tribunals. And all of this has had an erosive effect on people's expectations and their understanding. So it's really important, and it needs to be recognised, the significance that the new Labour government has put this bill together. Yet there is an expectation, I think, around balance and consultation and reasonableness within the provisions that are set out here and the regulations that are going to contain the detail of this idea of reasonableness, and trying to attach that onto a culture where the status quo, what is considered to be normal, has become great unreasonableness. So, for example, the provisions in relation to 0 hours contracts, if you read them, they are horrendously complicated, illustrating how difficult it is to get us out of this situation that we've got into, where 0 hours contracts have been normalised. How does one define what an exploitative 0 hours contract is? And so, over pages and pages and pages, this bill looks at how to provide an offer of a guaranteed hours contract, when, what the difference is between the 0 hours or small number hour contract that the person engaged in, and then what has happened in practice and the difference between them, and when those differences become significant. How to prevent that offer of the guaranteed hours contract from being an inferior contract in some way. How to provide remedy. So what is suggested is that the remedy should be that if you manage to take this to a tribunal, then what you are provided with is some recompense for the work that you may have lost, that there's not a compensatory measure, that's looking at compensation around loss of earnings. More bizarre, perhaps, are the technicalities around notice for a shift. So, how far in advance should a worker be notified of a shift? Then, in what situation should a worker be able to complain about the shift then not transpiring? And are workers going to go to employment tribunals to get recompense for shifts that they weren't paid for? So there are these complexities which I think one of the things that, in addition to the welfare reforms which have pushed people into taking zero-hour contracts, have also been linked to the regulation of agency workers since 2010. I think the regulation of agency workers was a push factor for the rise of zero-hours contracts because it incentivised employers to directly employ workers on zero-hours contracts if they were going to have to provide comparable pay and basic conditions for agency workers. So we may see that one of the effects of this attempt to tighten up on zero-hours contracts is that it leads to a renewed interest in agency work. And perhaps that would be no bad thing. Perhaps it would prove more tangible to be able to regulate agency work than it is zero-hours contracts. It's also likely to increase self-employment. So those issues to do with how we define the difference between a worker and a genuine self-employed worker become very critically important in terms of what the effects of this bill are actually going to be. That's very important that we see how this bill fits within a complex interplay, particularly around welfare law. And I think we really do need to wait and see what the government are going to propose in terms of welfare law, because this is not just to do with the legacy of austerity, it's also to do with COVID. So between September 2022 and May 2024, there were 1 million workers, people who already had a job, who have been required to take additional jobs or additional hours. And if they don't have good reason for doing that and they're entitled to welfare payments to subsidise their wages, then they get sanctioned. So this has also been driving the take-up in zero-hours contracts. We have the in-work progression scheme, where workers with low wages are encouraged, with the threat of sanctions now, to take up additional jobs. And so that side of the subsidy that employers have been getting for poor quality work from the social security system also needs to be looked at and addressed. So I wanted to use that just to briefly talk about the glimmer that there is in this bill around collective bargaining, although it expressly says that it's not to be defined as collective bargaining, but I see that as a positive, something that's positive to do with not disrupting unions who are looking to gain recognition for collective bargaining at a workplace or employer level. And that's in adult social care. And adult social care for an awfully long time, for almost 20 years, has been a site of a very appalling, poor quality employment, rights violation, low pay, huge turnover of workers, and violations of human rights of people in receipt of adult social care, as well as those of the workers who deliver the service. So to read about the adult social care negotiating body is really, really positive, something that needs to happen. And it's important because the plan to make work pay also makes the commitment that this model will be reviewed and there'll be an assessment as to whether it's suitable to roll out to other sectors. So it's good to see that although most of this does depend upon regulations, that there is a commitment to ensure that this negotiating body is made up of trade union representatives and it's made up of employer bodies too. And that the agreements that are reached will then go to the Secretary of State. And the Secretary of State is given powers to be able to refer back to the negotiating body where the Secretary of State perceives that there are problems with these agreements, and also that the Secretary of State has the power to be able to ratify these agreements. And on ratification, then in relation to pay, that the pay supersedes what's in the contract, and on non-pay matters, it's incorporated into the contract. And I think actually in relation to adult social care, this role of the Secretary of State in ratifying these agreements is very important because it ties the state in relation to the terms and conditions of work in adult social care, which I think then raises a lot of questions about the comparability of the adult social care sector to other low-wage sectors. So workers in adult social care are delivering a state responsibility in terms of the delivery of care services to those who are in need of care. We can't say the same for parcel delivery services or hairdressing, for example. So I think we need to be quite cautious and careful about the idea that this model will be directly transferable to other kinds of sectors, but it's a very important starting point and something to be welcomed.
Well, I think this is a generation opportunity to reset not just the labour market but also the wider economy. I think it's a start, but what we fundamentally need is a labour code of the sort we haven't really had in this country, but other countries have in mainland Europe. A code of rights established, I think, through legislation, on top of which there would be collective bargaining. And at the pre-contract level, the labour market as a whole has to be regulated through social security law in such a way as to guarantee pre-contractual rights for people when they enter the labour market, as a point Lydia was just making. If we're forcing people to take up low-paid, casual and insecure jobs, the social security system plays a major part in that. Also, critically, since the mid-1980s in this country, we've had a policy of, on the one hand, deregulating the labour market, whittling away at collective bargaining, reducing individual employment rights, and also in the area of social security, using tax credits to then subsidise low-paid work. So this is the worst of all possible worlds, because this means that public expenditure is going up to meet the gap between what people need to live on and what employers can get away with paying, because we no longer have collective bargaining. So Ewan mentioned some figures earlier to do with national insurance, and the amount of money that will be raised by having more stable employment and also more people having employee status is considerable and will go a long way towards filling this so-called 22 billion gap. But what he might also have mentioned, and we could also discuss later if it's helpful, is that more stable employment and higher wages would mean a lower tax credit bill and less money spent on fiscal reliefs to employers for not offering a decent and living wage. Filling the exchequer gap is something that labour law can contribute to. Establishing more stable employment indicates, I think, significant gains fiscally for government. But not just there. Why would giving people labour rights lead to enhanced productivity and higher employment? When I cite these studies which suggest that improving people's labour rights can lead to higher employment, most people don't believe this, because for the past 30 years we've been told the opposite. We've been told that labour market flexibility is critical, and there's a contradiction between people having rights and people having jobs. You can have rights or you can have jobs. Why does the evidence suggest otherwise? Well, for one thing, why is investment been going down in a period when labour rights have been getting worse in this country and shareholder rights have been getting stronger? You would think that over the last 30 years, with weaker labour rights, and also, by the way, something you will no doubt discuss in a few weeks' time, stronger corporate governance rights, why do we have such a poor record of investment in this country? And I don't just mean public investment, which is one thing, but private sector investment. The labour share, the amount of national wealth going to wages, has been steadily going down since the 1980s, and the capital share, the amount going in dividends and share buybacks and rents, has been steadily going up, but investment hasn't risen. Where's that money going? Largely into speculation in shares and real estate. And real estate and speculation in the financial markets are not productive sectors. They're sucking effort out of what might be a productive economy, but also that sort of investment is fueling a highly unstable financialised economy, which produces things like the global financial crisis that we experienced acutely in this country. It basically began here and in the United States in 2009. This sort of labour law reform that we've now seen is, I think, a very important first step, but is only a first step. to a much more comprehensive labour law that we need, but also a social law that would include social security law, and a corporate governance law that democratises decisions over investment and resource allocation, and also actually would really help capital. It's a paradox to say that capital needs labour regulation, but actually capital, if it's to be made to work properly, needs to be in a better balance with labour. In this country, for a long time, labour has been too cheap and capital has been too expensive. That's why we're not seeing sufficient investment. Actually, it's difficult for many companies to raise the capital they need for production as opposed to speculation, partly because of all the corporate governance rights loaded onto listed and other companies, and also because of the lack of public investment. That's also part of it. So crowding in private investment through more public sector investment, putting in place rules and regulations that we need across financial and labour markets would be a meaningful step forward. Why shouldn't the UK be the country to set the lead in this respect? We've been going backwards for the past 30 years, and we've looked somewhat enviously at other countries that have a better record on this. But if we go back to the 19th century, we weren't just the first industrial country, but we were the first country to have an effective labour code in the form of factory legislation. The Factory Acts of the 19th century were the first laws anywhere in a modern economy to set working time standards. And we had the best laws in that respect for many decades, and other countries followed us. We also had some of the most effective collective bargaining on a more voluntary basis to begin in the 19th century and in the 20th century. When we had effective collective bargaining and the Factory Acts in this country, there was a period of rising wages in real terms, something we haven't had for the past 30 years here, but also improved returns to capital. Capital returns went up and firms were more profitable in their manufacturing sector when there was strong collective bargaining and a strong statutory underpinning to our economy. So this is what I hope that we will see going forward. There'll be a huge debate about this. There'll be an immediate pushback in the next few days from those who argue that we can't afford these rights and that they will in fact hamper the economy and deter investment. So this is a first step. We'll have an argument about this going forward, but I'm reasonably optimistic that some of the points I've just made are behind this law. Okay, it's very detailed provision in many respects, and maybe too detailed. But from conversations I've had recently with people, civil servants and others, who will be shortly drafting impact assessments, and politicians who are going to make the case for this sort of law, the economic case will be made, and I think that's going to be very important. Thank you.
Okay, so now I'd be very glad to open it up to the audience. Hands up if you've got questions or comments. We've got lots of things to discuss. The sort of 4 topics across the bill that I spoke about. We've got these ideas of the dimensions of collective labour law and how they interact with individual labour law, of